Good afternoon, Chair Maroney, Chair D'Agostino, ranking members Rutigliano, Ciccarella, and members of the committee. My name is Jess Miers, and I serve as Legal Advocacy Counsel for the Chamber of Progress, a tech industry coalition committed to ensuring all Americans benefit from technological leaps. Today, we're here to recommend against drafting any legislation that could counterproductively put children at risk and disrupt the online experiences of all users, including adults. Though well-intentioned, these bills, including SB 395, HB 6253, and HB 6393, risk eroding access to critical resources and privacy for everyone online. We agree that protecting young people online is an important goal. In recent years, many platforms have heard the concerns from parents and researchers and have implemented new features to protect younger users. For example, in 2021, Instagram rolled out new settings that give teens and parents more control over potentially upsetting content. And platforms like YouTube Kids, provide an alternative and curated experience specifically for children. However, in drafting the legislation at issue today, we urge you to steer away from adopting similar legislation like California's age-appropriate design code, which is currently facing a constitutional challenge, and keep two principles in mind. First, the legislature should avoid forcing platforms to decide what content is considered age appropriate for every minor user, as this could result in the over-removal of information. To avoid liability, covered platforms could take a broad view of content considered harmful and censor it for anyone under the age of 18. Covered platforms could be forced to block older teenagers from accessing developmentally appropriate information simply because it would be inappropriate for much younger children. For example, resources for LGBTQ+ youth or other vulnerable groups looking for support could be removed because they would not be appropriate for all users under 18. Second, requiring platforms to deploy age verification tools could sacrifice all users' privacy in the name of increased security. Any attempt to regulate children's access to social media will require platforms to differentiate between adult users and child users. Platforms would almost certainly be required to collect some age-related information via checkpoints, such as demanding identification documents or even facial recognition from all users, including adults. In other words, covered platforms would be forced to collect even more sensitive data of everyone online. With that, age verification also discourages free expression, as anyone looking to participate in online discussions would be forced to disclose personal details before accessing the platform. Beyond all these points, federal law, such as the Children's Online Privacy Protection Act, already provides substantial benefits for children. In summary, we urge you to avoid the mistakes made in other states by prioritizing the needs of marginalized teens and avoiding age verification requirements that would sacrifice all users' privacy. Thank you for your time.
Thank you. Are there any questions? So I guess I have a question. I have a few. We'll go in. And, like with anything, I agree with some of your points. I disagree with some of them. So I'm going to try to push back on some of these things. I do agree that it's important. Again, for all of the harms of social media, I do feel that people can find communities. And I do think of the students who may be LGBTQ+, who, whether that need that support, that they feel they can't get it from their parents, right? And so I don't want to deny that support. And so, but one point I'm going to push back on you on is when you mentioned that the changes that Meta had made, with Instagram and with Google, they really only came after the age-appropriate design code went in effect in the UK. I mean, to their benefit, though, the positive is they brought them worldwide, right? They didn't just do it in the UK, which they could have done, right, and just kept it there. But with that, you mentioned the constitutional challenge, right? So I believe a lot of that is based on, was it the Reno versus or ACLU versus Reno versus ACLU case? So I've heard some, obviously with anything, you're going to hear from some people that they're going to win, they're not going to win, depending on what it is. But does the age verification kind of go towards that, the content moderation, which would then go towards kind of a free speech violation? Is that the concern? Am I understanding that correctly?
That's correct. Age verification, because it would apply also to adult users as well, because there's no way for the internet services to be able to specify or figure out what the age of their users are without using age verification. The idea behind that is then, first of all, adults would have to give over that information. But more importantly, second of all, if adults didn't want to give over that information and be verified, then they wouldn't be able to have access to information that they would otherwise, be permitted to have access to under the First Amendment.
So I guess it's some ways it's counterintuitive that age verification actually it almost goes against data privacy in some ways, right? In that you're requiring more information from someone. And in some states, I'm sure you're familiar with the Louisiana bill that they're required to upload their official state driver's license, which we define driver's license as sensitive information to Connecticut data privacy. So you're giving away sensitive information in order to access. Is that
That's absolutely the concern. We also heard, Utah is considering a similar bill. And during that hearing, several parents even testified that they were not comfortable with their kids having to face facial recognition, for example. They were not comfortable themselves with having to provide government documents to these websites.
now with that being said, how do we go to there are ways though, right, where we can determine that some because you mentioned COPPA, the federal law for children's protections, they define some sites that are likely, I don't know if it's likely to be accessed by children. I'm not sure of the term of our, what the correct term is in the law, but how are they determining? And then would using something like that, that definition.
Yeah, so the guidelines are a bit different with COPPA. I believe they just have these web services just have to ask whether select or check a box that they're over the age of 13 and provide guidance that if they're under the age of 18, then they can't, use the service depending on other factors as well. The problem with, contrasting that with these age appropriate design bills is the age assurance language. In the UK, since we've heard this bill compared to the UK version, the UK regulatory and litigation frameworks are incredibly different from the US, even to the point that we're talking about a code, which is actually operating more like a guideline in the UK versus here in the United States, an attorney general could bring, based on their own politics or whatnot, a challenge against these services, and immediately the lawsuit would kick off, which would bring about all sorts of expenses and also chill speech as well. So these services, the only way that they can be sure that they are free of liability or risk is by actually making sure they don't get it wrong when they're verifying these users. And that's why we are so concerned about facial recognition government documents.
Now, in the current bill, the Connecticut Data Privacy Act, we use a standard of you have actual knowledge or willfully disregard, right? And there was, so I mean, with using that standard going forward, again, there wasn't, I can't say industry was thrilled with it, but there also wasn't, it was agreed on in the end that was our standard. So do you have any comments on utilizing that as the standard?
I think, again, I think an actual knowledge standard is probably more appropriate than a constructive knowledge standard if we had to pick between the two. Still, though, these services, because they know that anyone can access their websites, including children, they will likely still move towards trying to make sure that they can adequately verify the ages of those children, because they don't want to be on the hook if they do get something wrong.
I just think I disagree with you a little on this in terms of I think when it comes to children, I think that the actual knowledge may be too high, right? I think that using the constructive, but I understand that we don't want to age gate the internet, right? And so how do we strike that balance that we're protecting our children, but we're also not inhibiting, the access of adults to enjoy. So with that, are there any further questions?
I thought I heard you say, I apologize, maybe I missed part of it. I thought I heard you say that there was a concern about if you have these sort of gatekeeping issues with people uploading information, they couldn't access information which they'd have a First Amendment right to access. I just was curious as to what you meant by that, because obviously when we're talking about, you don't have a First Amendment right to use Facebook. So what did you mean when you referred to the First Amendment?
Right. So this gets at again, I think the ACLU v. Reno case, which talks about access to pornographic material. The First Amendment, it does apply to your right to be able to both express yourself, speech, but it also includes material that you wish to consume as well. And so that was sort of the issue with the ACLU v. Reno, is that, again, adults, they are legally allowed to or permitted to enjoy pornographic materials as per their First Amendment privilege.
I guess I need to read the case. I always thought the First Amendment applied to government, and you don't have a first. Is that what the case is about? Whether you have a First Amendment right to
I think I
consume
understand
material from the internet?
I think I understand the confusion there, if I can. So, the First Amendment applies to the government. The government cannot abridge the free expression rights of private citizens. So, in a way, by forcing by telling adults what they can and cannot consume online or offline, that would be an abridging of an adult's First Amendment right. That would be the government abridging those adults' rights.
Well, I assume the case hinges on whether or not just putting in place rational restrictions on how you consume that is the same as abridging your right to consume it, right?
The case has to do with children's access to pornographic material. And again, it's very similar to this age-appropriate design issue, where the government is trying to implement standards online that would not just be limited to kids' access to pornography, but it would also extend to adults' access to pornography materials as well. And because those limitations would reach adults, that is why it would be unconstitutional.
Interesting. Okay, thank you.
All right. Thank you very much for your
Thank you.
testimony.